Imagine waking up tomorrow and the government has the legal right to walk right up to your front door, knock, and tell you that the most popular rifle in America, the firearm sitting safely in your home right now for self-defense, is completely outside the protection of the United States Constitution. Imagine them telling you that because a state capitol or a liberal city council passed a piece of paper, your property is now contraband, and you are a criminal just for holding on to it. Imagine further that tens of millions of other law-abiding Americans are in the exact same position, all of them facing the same message. The rifle you bought legally, the one you trained with, the one you rely on to protect your family, has been declared beyond constitutional protection by courts that decided the words of the Second Amendment simply do not mean what they say. That is not a fantasy scenario pulled from some dystopian novel. That is the exact reality millions of gun owners in states like Illinois, California, Washington, Maryland, and Virginia have been living under for years. But right now, as we speak, a massive structural shift is happening behind the closed doors of the United States Supreme Court. And the two cases at the center of it could determine whether Americans permanently reclaim their constitutional right to own the AR-15 and the standard capacity magazines that go with it. Today we have breaking news on both of those cases, and what happened at the Supreme Court over the last several days just shifted the momentum in a very significant way. So stay with me, because by the end of this video you are going to understand exactly what happened, what it means, and why the next few weeks could be the most consequential stretch of time for gun rights in the post-Bruen era. Now, before we get into all of that, if you want to support what we do here, one of the simplest things you can do is subscribe and double-check that YouTube has not quietly unsubscribed you, because they do that more than most people realize, and it directly affects whether content like this reaches the people who need it. Also, I want to take a moment to thank one of this channel's biggest supporters, First Form. Their culture, their values, and their commitment to pro-freedom, pro-America principles is something that sets them apart from every other supplement company out there. If you are trying to get healthier, if you are trying to perform better, check them out using the link in the description. And right now, if you order using that link, you can get a free 5-pack of protein sticks with your order. I can tell you from personal experience, they are worth every bit of it. So check them out. Link is in the description. Now let us get into this, because what we are discussing today is not just a procedural update from the court's docket. This is the story of how a permanent nationwide end to assault weapon bans is being actively pushed forward through the Supreme Court right now through 2 separate case vehicles, and why the moves the court made this week tell us something very important about where this is heading. The 2 cases at the center of all of this are Viramontes versus Cook County, which is the rifle ban challenge out of Illinois, and Duncan versus Bonta, which is the magazine ban challenge out of California. Both of these cases went to Supreme Court conference recently, and both have now been relisted for an upcoming conference date. And I want to walk you through exactly what that means and why it matters, because if you do not understand how the Supreme Court's conference and relist process actually works, you will completely misread what is happening here and draw exactly the wrong conclusions. Cook County, Illinois has had an ordinance on the books for years that makes it a crime to sell, transfer, or even possess what the county calls assault weapons. That ordinance has been in place for a long time, and until Bruen came down in 2022, challenges to it were going nowhere fast. The legal landscape for the Second Amendment looked completely different before Justice Thomas wrote that landmark opinion. Lower courts were routinely upholding gun restrictions using an interest-balancing test, basically asking whether the government had a good enough reason to restrict your rights. And that test had nothing to do with the text of the Second Amendment or the historical tradition surrounding it. Courts were essentially free to weigh policy arguments and reach whatever conclusion matched their political preferences. Bruen changed all of that, or at least it was supposed to. The court said clearly that interest balancing is off the table. The only question is whether the restriction is consistent with the historical tradition of firearm regulation in America. If the government cannot point to a historical analog from the founding era, the law is unconstitutional. Full stop. After Bruen, a fresh challenge was brought against Cook County's ordinance. The petitioners include individual citizens who live under this ban and cannot legally possess the firearms they believe they have a constitutional right to own, along with organizations like the Second Amendment Foundation, who have been litigating these battles in courts for years. Their argument is straightforward. Under Bruen, the government now bears the burden of proving that any gun restriction is consistent with the historical tradition of firearm regulation in this country. And when you look at the historical record, there is simply no tradition of the government banning entire categories of commonly owned firearms based on cosmetic features or a rifle's resemblance to a military weapon. The founding generation owned cannons. They owned the military weapons of their era. The idea that the Second Amendment protects only certain aesthetically acceptable firearms, while excluding others based on how they look, would have been completely foreign to the framers. But here is where the lower courts came in and created a serious problem. While this case was working its way through the federal court system, the state of Illinois decided to pile on and pass a statewide assault weapon ban of its own, a law known as the Protect Illinois Communities Act, which we have covered extensively. And around the same time, the Seventh Circuit Court of Appeals decided a case called Bevis v. Naperville and upheld Illinois' assault weapon ban by concluding that AR-15s are too militaristic to be protected arms under the Second Amendment. Think about how backwards that reasoning is. Their logic was that because these firearms are useful in military service, the government can restrict or ban them from civilian ownership. That reasoning is not only wrong, it is exactly backwards from what the Supreme Court held in Heller. Justice Scalia's majority opinion in Heller explicitly said the Second Amendment protects arms that are in common use by law-abiding citizens for lawful purposes, and the AR-15 is, without any serious dispute, the most commonly owned rifle in the United States of America. There are somewhere between 20 and 25 million of them in private hands right now. People use them for home defense, for hunting, for competitive shooting, and for recreational target shooting. The Seventh Circuit decided to pretend that fact does not matter. The district court, bound by what Bevis already said, then ruled against the petitioners in the Cook County case. The Seventh Circuit affirmed that ruling, and that is what brings us to where we are today. The petitioners took this fight directly to the United States Supreme Court, asking the justices to step in and resolve this question once and for all. Now, here is something that gives this challenge an important dimension beyond just the legal merits, and it is something the gun rights community has been tracking very closely. After the Supreme Court declined to take up a prior rifle ban challenge known as Snope v. Bruen out of Maryland, Justice Kavanaugh wrote a statement in connection with that denial, and his statement was not ambiguous. He said plainly that the issue of whether states can ban commonly owned semi-automatic rifles is a question the Supreme Court will need to take up, and he signaled that could happen within a term or two. That is a sitting Supreme Court justice going on record to tell the country that this constitutional question must be answered. The petitioners in Viramontes v. Cook County are essentially holding Justice Kavanaugh to that statement. They are saying, you made a commitment to the American people. You acknowledge that the lower courts are getting this wrong. This case is the vehicle. The time is now. Cook County, predictably, has responded by arguing the court should deny review. Their argument breaks down into three main points. First, they claim there is no circuit split on the rifle ban question, meaning the lower courts are not divided enough to require Supreme Court intervention. Second, and this is important to understand, they argue the petitioners failed to properly develop the factual record in the lower courts, that the plaintiffs were in such a rush to reach the Supreme Court that they skipped the discovery process and failed to put admissible evidence in the record to support their constitutional claims. This is the procedural vehicle argument, and it is a real one that deserves to be taken seriously. The Supreme Court generally wants a clean case with a fully developed record, not one where it has to guess at facts that should have been established in the trial court below. Third, Cook County contends the lower courts simply got this right on the merits and there is nothing for the Supreme Court to correct. If the court agrees that this case has procedural defects serious enough to prevent clean merits review, they may pass on it entirely and wait for a better vehicle to come along. That is exactly why understanding what the realist actually tells us becomes so important, and that is where we need to spend some time with the data. Now let us talk about Duncan versus Bonta, because this one has its own history that is frankly infuriating if you have been following it at all. California's ban on standard capacity magazines, meaning any magazine that holds more than 10 rounds, was challenged in Duncan. The case made it all the way to the Supreme Court previously, and the court granted the petition, vacated the lower court ruling, and remanded the case back to the Ninth Circuit with instructions to reconsider it in light of Bruen. That is what is called a GVR, grant, vacate, and remand. It happens when the Supreme Court wants the lower court to take another look using the correct legal framework. And what did the Ninth Circuit do when they got that case back with those explicit instructions? They used an en banc panel, a stacked full court configuration, to delay, manipulate, and ultimately uphold the ban anyway. They took another look, applied what they claimed was a Bruen analysis, went through the historical tradition exercise, and came back with the same result. The ban stands. The Supreme Court had already told them to reconsider, and they came back to the same place. That is not an accident or a genuine legal disagreement. That is a pattern of deliberate non-compliance with Supreme Court precedent, and it is exactly the kind of lower court defiance that eventually forces the Supreme Court's hand. When a circuit court ignores a GVR and comes back with the same unconstitutional result, the Supreme Court cannot simply let that stand without its own authority meaning nothing. So now both of these cases went to Supreme Court conference on the same day. And here is the critical update that just came out of that conference. Both cases have been relisted for the next conference date. And I want to make absolutely sure you understand what that means and what it does not mean, because this is where a lot of people in the gun rights community jump to conclusions in both directions, either panicking and reading it as rejection or celebrating as though a grant is already confirmed. Neither reaction is correct. A relist means the justices did not vote to grant or deny the petition at the conference where it was first considered. Instead, they put it back on the calendar for further consideration at a subsequent conference. Why would they do that? There are several possible reasons. One or more justices may be writing something, whether that is a concurrence, a dissent from denial, or most importantly, a vote to grant that they want other justices to join before it is finalized. The Chief Justice or another member of the court may have asked for additional time to review the petitions and the responses in detail, or the justices may be actively debating whether to take the case and need another conference session to reach a final decision. None of those reasons are bad news for gun owners. In fact, when you look at the historical data, the opposite is true. The numbers on relists are genuinely encouraging, and I want to walk you through them carefully because they completely reframe what this moment means. Based on Supreme Court tracking data, a case that is immediately denied at its very first conference is dead on arrival. The petition gets no second look, no further consideration, and that is the overwhelmingly common outcome. Well over 99% of petitions filed to the Supreme Court are rejected. They are denied at the first conference and never heard from again. The court receives thousands of petitions every term and agrees to hear only a small handful of them. So the baseline odds for any given petition are vanishingly small, but the picture changes dramatically the moment a case gets relisted. Petitions that receive even a single relist are granted certiorari at a rate ranging from 31 to 43%, depending on the term you examine. That is not a guarantee, but it is a statistical transformation from the baseline. And here is the number that really puts everything in perspective. Between 66 and 75% of all cases that the Supreme Court ultimately agreed to hear during the periods that have been studied were relisted at least once before the court officially granted cert. What that tells you is that relisting is not a stalling tactic. It is not the court kicking the can down the road. It is what the court does when it is seriously engaged with a petition, when justices are actively deliberating, writing, and working toward a decision. A relist is almost always a green light that the petition is being taken seriously, not a warning sign that denial is coming. But I also have to be fully honest with you because you deserve the complete picture and not just the optimistic framing. Multiple relists tell a different story, and this is the pattern we have to watch carefully going forward. When you see a case get relisted 2, 3, 4, 5 times in a row without resolution, the data shifts significantly in the other direction. The more consecutive relists a case accumulates without a grant, the more the statistical probability moves toward eventual denial. When you see a case relisted many times, it usually signals one of two things. Either the justices are genuinely divided about whether to take it and cannot reach the 4 votes needed to grant cert, or one of the justices is writing a lengthy statement, concurrence, or dissent from denial, explaining why they believe the court should have taken the case but could not get enough colleagues on board. We saw this exact pattern play out with Snope versus Bruen, the Maryland rifle ban challenge. That case was relisted multiple times, accumulated a long string of conferences without resolution, and was ultimately denied. Justice Kavanaugh did write his statement alongside that denial, which matters enormously for where we are today, but the case itself did not get granted. That is the outcome we are trying to avoid with these two cases. So the message right now, after just one relist for both Viramontes and Duncan, is cautious optimism grounded in the data. One relist puts us in the most favorable statistical zone. The challenge going forward is to see a grant before the relist count climbs high enough to signal a problem. There is also a broader strategic dimension to all of this worth taking time on, because these two cases are not operating in isolation. Since Bruen came down, the lower federal courts have been in a state of genuine chaos about how to apply it. Some circuits have taken Bruen seriously and struck down gun restrictions that lack historical analogues. Others, most notably the 7th and 9th Circuits, have done everything possible to limit Bruen's reach, create carve-outs the opinion never authorized, and reach the same pro-restriction conclusions they were reaching before Bruen, using language that superficially sounds like Bruen analysis. The Supreme Court has already had to re-enter this space with decisions like Rahimi, which addressed firearms restrictions connected to domestic violence protective orders, and reinforced that the historical tradition test is the correct framework. But on the specific and central question of whether states can categorically ban the most popular rifle in America and the standard magazines designed to go with it, the court has not yet issued a definitive ruling that leaves no room for lower courts to maneuver around it. Every time the question has gotten close, it has either been denied or sent back down with a GVR that the lower courts then find ways to sidestep. That dynamic cannot continue indefinitely without the court's own authority being seriously undermined. The millions of Americans who own AR-15, who bought them legally at licensed dealers, who passed background checks, who use them for home defense, for hunting, for competitive shooting sports, for recreational target shooting, deserve a definitive answer from the highest court in the land. And that answer, under any honest reading of Heller, Bruen, and the deep historical tradition of arms ownership in America, should be that these firearms are constitutionally protected. The government has produced no historical analog for banning an entire category of commonly owned arms based on how they look or how quickly they fire. There is no tradition in American history, not in 1791, not in 1868, not in any of the relevant founding era periods the court has identified, of the government telling citizens they cannot own the standard civilian firearm of their era. In fact, the historical tradition runs in exactly the opposite direction. Americans have always owned and carried the military pattern arms of their day. The musket that hung above the colonial fireplace was also the standard infantry weapon of the Continental Army. That continuity between civilian and military arms is not an argument against constitutional protection. It is the core of what the Second Amendment was designed to preserve. Here is the other piece of this that matters enormously for where we are right now. Viramontes and Duncan are both in the Supreme Court's pipeline at the same time. That is not a coincidence from the court's perspective, and it is not an accident that both petitions landed at conference on the same day. If the justices are looking for a clean path to take up both the rifle ban question and the magazine ban question in the same term, resolving the two most contested hardware questions in Second Amendment law, simultaneously, having both cases relisted together and moving through conference together gives them exactly that structural opportunity. They could grant both petitions, consolidate the cases, schedule a single oral argument session, and issue one landmark ruling that definitively resolves both questions. That would be the most sweeping and consequential Second Amendment decision since Bruen itself. It would send an unmistakable message to every state legislature, every county commission, every activist circuit court judge, and every gun control advocacy organization in the country that the era of evading the Second Amendment through bureaucratic creativity is permanently over. Cook County is going to keep fighting this at every turn. California is going to keep fighting this. They have every possible incentive to delay, to raise procedural objections, to argue vehicle defects, to manufacture reasons why this case is not the right one, and this term is not the right time. Because they know exactly what happens if the Supreme Court reaches the merits of these questions and applies Bruen honestly. They lose. They have always known they would lose on the merits. The entire strategy of these gun control jurisdictions for the past several years has been to run out the clock, exhaust gun rights organizations financially through years of litigation, hope that the political composition of the court eventually changes in their favor, and keep the lower courts in a state of deliberate confusion for as long as they possibly can. Every procedural objection Cook County raises, every demand for a cleaner vehicle or a better developed record is part of that delay strategy. They are not making good faith legal arguments. They are buying time, and they know that when the time finally runs out and the Supreme Court reaches the merits, there is not a single law from 1791 they can point to that authorized the government to ban a firearm possessed by more than 20 million law-abiding Americans. Here is where we stand right now, and this is the part I want you to remember. Both Viramontes and Duncan have survived their first conference. Both have been relisted, which places them statistically in the group of petitions that have a genuinely meaningful chance at certiorari. The next conference date is approaching fast, and what happens at that conference will tell us a great deal. If we see a grant, it will be one of the biggest news days in Second Amendment history. The moment the court finally agrees to answer the question it has been circling for years. If we see one more relist, we stay measured, we stay focused, and we keep watching. If we start seeing 3, 4, 5 relists piling up without resolution, we need to honestly assess whether these vehicles are going to make it or whether the fight shifts to finding the next best case. What I can tell you with confidence is this: the momentum right now, after this first relist, after Kavanaugh's statement on Snope, after years of documented lower court defiance, is pointing toward the Supreme Court eventually having to act on this question. The only open questions are when it happens and through which case. And for the first time in a long time, we have 2 cases simultaneously in striking distance of a definitive answer. We are going to be watching the order lists very closely over the coming weeks. The moment we get an update, whether that is a grant, another relist, or a denial, we will be right here breaking it down for you in complete detail so you understand exactly what it means and what comes next. This fight is not over. In fact, for the first time in a while, it feels like it may just be beginning in the right direction. If this video gave you value, if it helped you understand what is actually happening in these critical cases, please like, comment, and subscribe. Check out 2 of our other videos here on screen that the YouTube algorithm thinks you will find helpful. And as always, thank you so much for your continued support.